Hi, I'm attorney Eric Traben. I'm a former Florida State prosecutor, and currently I'm a private defense attorney serving all of Central Florida. In this video, we're going to talk a little bit about police searches, specifically warrantless searches. Now, many people believe that the police are never allowed to conduct any search or seizure of evidence without a warrant. While it's true that warrantless searches are presumed to be unconstitutional, the fact is most police searches and seizures today are being conducted without a warrant, and they're found to be completely legal and constitutional. How can this be? Well, there are 5 general basic exceptions to the warrants requirement. These exceptions are consent, plain view, search incident to arrest, some vehicle searches, and exigent circumstances. First, let's talk about consent. If you give the police permission to search your property, then that's all they need. Whether it's a search of your home, your car, or even your body, giving permission or consent to the police generally will protect them from any other legal requirement. Now, of course, there's always going to be a question of whether or not that consent was freely and voluntarily given to the police. And it's important to have your defense attorney review all of the details surrounding those issues thoroughly. Nonetheless, having consent from a suspect or a defendant lets the police conduct a search of almost anything without having a warrant and without seeking judicial review. So when you find yourself in that situation, if the police are asking for your permission to search, you should tell them no. And here's a tip. If the police are asking for your permission to search something, that usually means they need it, and that they wouldn't be able to get a warrant, or that they don't have some other exception to the warrant requirement without your consent. So if they're asking your permission, you should politely but firmly tell them no. The second exception to the warrants requirement is what's called plain view. If the police are in a place that they're allowed to be, and they see something that's out in the open that's illegal, they don't have to cover their eyes and pretend that they don't see it. For example, if the police pull you over for speeding, and in your front passenger seat they see a big plastic baggie filled with the Heisenberg sky blue crystal meth, they don't have to cover their eyes and say, "No, I didn't see that." They're going to act on it right then and there. Now, there's a lesson here about not keeping things out and about and putting things away when you're done with them. But one of the most easiest ways for the police to seize evidence that you don't want them to seize is to just leave it out in the open. So put your things away. Third, there's what's called search incident to arrest. Now, if you're being arrested, you're already having a pretty bad day. And unfortunately, for the most part, no one's really expecting to get arrested. But when a person is arrested, the police conduct a very thorough search. They search your clothes, they search your body. And they do this to make sure that there's no contraband or anything dangerous that might be brought into the jail or that could be used against them when they're arresting you. And so anything that they find during that search while you're being arrested is going to be considered to be fair game. And because for the most part you're not expecting it, that you're going to be arrested, you can't really plan for that in advance. But if you find yourself in a situation where unfortunately not only are you being arrested, but you might have other things on your person, the best thing to do is to simply invoke your right to remain silent. And if asked about it, tell the police you wish to exercise your rights and you'd like to talk to a lawyer first. Fourth, there are certain exceptions to the warrant requirement that specifically apply to vehicles or cars. Now, a person does have a reasonable expectation of privacy when it comes to their car, just like they do for their home. But courts have concluded that the reasonable expectation of privacy a person has is lower in their car than in their home. After all, your car goes out in public. It has windows where people can see inside, and there are even laws that prevent you from legally making your windows too dark so a police officer couldn't see inside. As a result, although you do have some privacy, you have a lot less. And so although police officers may still require a warrant to search a car, or an exception like getting your permission, one thing that they have as an exception that applies to cars that doesn't apply to certain other areas is that simply having a well-founded belief or probable cause that there is evidence of a crime inside the car, that's enough to give them permission to search the car. Now, the classic example was the odor of cannabis. If police officers said they smelled marijuana, oftentimes that was all they needed to do a thorough search of a car. As the legal status of cannabis evolves across the country, judges and courts are starting to interpret this a little bit differently. And there's no uniformity. Not every judge is doing the exact same thing. But the underlying principle remains the same. If the police have a reasonable belief that there's evidence of a crime that might be found in a car, they're going to be allowed to search that car without a warrant and without your permission. Fifth, and finally, there are what are called exigent circumstances. Exigent circumstances are basically an emergency situation where the police simply don't have time to go get a warrant. This could be an emergency due to someone having a medical episode where the police officer needs to enter property to try to help someone. Or perhaps someone's being attacked and injured. Perhaps the police officer is chasing a dangerous felon who's fleeing from committing a crime and they chase them into a house. All of these are scenarios that the police are going to rely upon as exigent circumstances to justify not being able to get a warrant. As you can expect, the police often claim exigent circumstances in far more situations than they maybe really are allowed to apply. Again, it's why it's so important to have a defense attorney carefully review all of the evidence in your case. So to recap, although the police need to have a warrant to do a search or a seizure, there are exceptions. The 5 basic exceptions are giving your consent, having something out in plain view, search incident to arrest, certain vehicle searches, and exigent or emergency circumstances. That's it for now. If you have any questions, you can check out our website at trabinlaw.com. That's Trabin, Trabin, law, law.com. Or you can even call or text your questions to 407-925-2949. Again, you can call or text us at 407-925-2949.